Welcome to our latest edition of the Labour Exchange, our regular podcast on topical labour and industrial relations updates. I am Manon Lamotte, an employment partner from our Paris office, and today I am joined by our Head of Labour and Industrial Relations, Tom Player, to discuss some important developments in terms of European Works Councils. The European Union has indeed agreed a new directive which significantly amends existing European Works Council legislation. It should make EWCs easier to set up, better funded and better protected. The current EWC directive outlines the processes for creating EWCs and for informing and consulting them on transnational matters, such as some cross-border M&As, outsourcing, restructuring and redundancies. Changes in the new directive include, for example, increasing workers' and EWC's rights, raising employers' costs, such as funding EWC experts, legal fees, training expenses, but also expanding the scope and breadth of management's EWC information and consultation obligations, requiring management to justify the confidentiality or withholding of information, removing the exempt status of legacy EWCs, and strengthening sanctions for non-compliance. Member states must implement the new directive by the 1st of January 2028. Some changes take effect from the 2nd of January 2028, and others will apply from the 2nd of January 2029. Welcome, Tom. Thank you. I wondered if you would be able to share some more insights into the new directive, please, starting with why has the EU introduced a new directive in December 2025?
Thank you, Manon, and good to be here with you today. Yes, it's quite some list that you've reeled off there, Manon, in terms of the changes under the new directive, which was eventually ratified just before Christmas, December 2025. I think there's a number of drivers for the EU wishing to re-legislate on this topic. The original directive, as you probably know, was introduced in 1994. It was refreshed again in 2009, and then some 16 years later, we have a new directive. Now, I've been around long enough to remember the second directive coming into effect, and I've advised a lot on that. There is a concern that EWCs, which are transnational sort of information and consultation bodies designed to help the flow and sharing of important information about restructurings, cross-border matters with employees, have not really been quite fit for purpose. So perhaps under-resourced, not properly funded, companies perhaps not taking their obligations to inform and consult on business proposals seriously enough. And there's been a view that they've been too little and consultation has been too late. And there's been a lack of proper sanctions and enforcements in some jurisdictions that EWCs are domiciled in. So growing pressure for EWC involvement in new workplace issues as well, Manon, is a factor. Things like challenges around AI, digital, just transition. And so the EU and the Parliament wanted to see a more expansive role for EWCs with greater rights, greater enforcement rights as well, to expand the remit of EWCs and give them more power, essentially.
Thank you, Tom. And looking more closely at the specific changes, I gather that EWCs are EU-wide information and consultation bodies that are required to consult on transnational issues. My understanding is that the definition of what amounts to a transnational matter that requires consultation with an EWC is changing. Can you tell us in what way, and please give us some examples?
Sure, yeah, it's tricky, this one, man, and I'll try to keep it as simple as possible. But if you imagine a big Europe-wide information and consultation forum, it's not the remit of a European Works Council to be consulted on single country issues, things that would typically come before trade unions or national works councils. Their role is to look at the bigger picture stuff, things that impact the group as a whole, or traditionally employees in at least two or more member states. I think that the problem with the way that this has evolved and where there's been friction between representatives and management is what should find its way onto the agenda of an EWC, putting it simply. So some companies, for example, they might invoke a closure of a business or a site in one EU country, and they will say, well, that's a single country issue. It doesn't affect anybody else in any other countries. But the EU Commission have decided that there needs to be more clarity on this. And so the new expanded definition means that if a proposal or matter can reasonably be expected to concern at least two entities in the EU or the group as a whole, it should be a matter for consultation. So what this is going to mean is that companies are going to need a forward-looking assessment about how company proposals, things that might happen in one country, for example, an outsourcing or restructuring, that what are the consequences and impacts of those changes for employees in another country? If they will affect employees in another country, then it should be on the agenda for the EWC.
Very clear, thank you. And I also gather that the scope and breadth of management's EWC information and consultation obligations is also changing. Can you please explain these changes?
Yeah, so EWCs are quite logical in how you should inform and consult. So if you have a transnational issue, a cross-border restructuring, for example, the expectation is that you will provide appropriate information to allow an in-depth assessment of the subject matter, and prepare to enable reps to prepare for consultation. And then the consultation will take place, and at some point the representatives will have the right to form an opinion on the company proposals. Now, what the new directive is saying is that there is an increased emphasis on the need for timely information sharing by management. So they must take account their obligations in the agreement or by law to consult with national bodies as well. So the timing of information and when you might share it with national bodies is a relevant factor. But there's a new entitlement for EWC representatives to not just give an opinion on any company proposals, but also to receive a written response from management to their opinion within a reasonable time. Now, that points to the fact that there should be meaningful dialogue, exchange of views, representatives providing an opinion, company responding in writing. That's going to lengthen consultation periods with EWCs. And the law is now being clarified to say that EWC members will have the right to update EU workers, and they should be provided with the means to fulfill this right as well. So timescales for managing information and consultation are going to become more important, as is the protocol for managing information and consultation with an EWC. So companies are going to need to think about when information is shared, how long consultation will last, when should the opinion be raised, how long it will take for the company to respond to that opinion. So this could mean a rewrite of existing EWC agreements.
Another important change, I appreciate that management will no longer be able to rely on a broad discretion to withhold information to an EWC on confidentiality grounds. How is EWC confidentiality changing under the new directive?
Yeah, this was something that the EU Parliament and the Commission got quite vexed about, Manon. I think there was a real worry that companies were not providing information to EWCs, or they were labeling everything that they shared with EWCs as confidential, and thus potentially trying to prevent EWC representatives from sharing that information at a local or national level, or being able to fulfill their job to act as representatives for the EU-wide workforce and disseminate information downwards. I think a confidentiality obligation is a really important provision of an EWC, and I think companies are going to have to think very, very carefully about the drafting of these provisions. So companies, any restriction on sharing information now on confidentiality grounds under the new directive must be in the legitimate interest of the business. And if you are going to withhold any information, you can only do that, based on objective criteria if it would seriously harm the functioning of the undertaking. And you will need to give a justification for withholding information on confidentiality grounds to the EWC. So this is going to essentially require the sharing of more sensitive information at an earlier stage of the process, which companies are going to have to adjust to and find ways of working away around with the EWC representatives.
So now, from a practical perspective, what will companies have to do with their existing EWC agreements in light of the new directive?
Well, as I said, I'm old enough to remember the last 2009 directive, Manon, and at that time, trade unions and works councils requested a renegotiation of existing EWC agreements. So there's lots of companies, multinational businesses across Europe that have existing EWCs, and they're either voluntary EWCs or they're negotiated under the previous directive. The voluntary EWCs will lose any particular exempt status, and therefore any company that operates a voluntary EWC can expect a request to renegotiate and set up a new EWC, and they won't be able to rely on the fact that they've got a legacy voluntary EWC any longer as a blocker to a negotiation on a new agreement. Secondly, I think companies will be forced over the next year or two to relook at their EWC agreements afresh and bolt in some of these changes I've described and renegotiate certain provisions of the EWC with their representatives. So companies that haven't already been approached will probably need to prepare for a discussion with their EWC and a strengthening of their EWC agreement.
Thank you, Tom. Are there any other brief comments you would make in terms of the planned changes and watch outs for companies, either with an existing EWC or if they do not yet have one?
Yeah, there's bits and pieces of miscellaneous provisions in this directive, Manon. For example, there's a requirement that future agreements should clarify the funding for experts. It used to be the case that one expert could be funded if it was necessary for the performance of representatives' duties, for example, if they needed specialist support on a restructuring. But now there's going to have to be much more clarity around the funding of experts, reasonable training costs for representatives, and there's going to be a need for greater clarity on things like legal costs for EWC representatives to enforce their rights, because that's been a bone of contention that reps don't have the resources to enforce rights under the existing directive. The other big change is to enforcement. So the EU have made it clear that member states implementing this new directive must introduce timely and effective procedures and remedies at national level to enable representatives to uphold their rights. So this points to increased financial penalties. Penalties must take account of the gravity, duration, consequences, and either the intentional or negligent nature of any company breach. So I think companies who are worried about enforcement, they're going to need to look at the jurisdiction in which their EWC is based. They're going to need to look at how the new directive is transposed into national law, and they're going to need to keep a watch out for fines and other penalties and an increase in fines and exposure for the company and greater risk. And possibly in some jurisdictions, as you'll know, Manon, France and Belgium being the obvious ones, there is also injunctive powers for EWCs to stop companies progressing with proposals or plans pending consultation with the EWC. So it may be that more EU countries will adopt similar measures to the French and Belgian model.
Thank you so much, Tom, for explaining the new directive and joining me today.
My pleasure.
Thank you all for listening, and please take a look at our website if you would like to obtain a copy of our latest briefing on EWCs.